Now, you admitted all of this paperwork, right, without me getting a copy of it. Yes. Mhm. And then you decided to have another motion hearing on 10/5. Right. As settlement conference setting action, notice of trial setting. Yeah. On 12/31. Now, sealed confidential report, declaration of Heidi Budnick, declaration mailing, temporary order. Now, this parenting plan, this temporary order of child support motion hearing, yes. Um, Motion hearing, you had from 9/14 to October 5th, right? And she said that she declared some sort of mailing. Yeah, but I didn't get any paperwork. No. Now, when I look at the court rules, I'm going to find out exactly how many days you would have had to give me. And if I find out that you were scheduling hearings where there was no possible way that my rights would have been enforced, yes, I'm going to sue you for that. Now, typically all other parties, yes, and the court are entitled to at least 6 days notice of a hearing in family law cases, yes. And in many counties, the notice requirement for family law motions is longer than the general civil. Um, because I'm going to get the court rules. I think I downloaded them at some point. They could be on a drive, yes. But if it's really 12 days, I'm going to look at, well, if you sent a declaration on the 25th, and that was 5 days before, yes. Because there was mail returned unclaimed on 1/14 of 2013, yes. Uh, was that for the trial clerk's action on February 11th? Yes. Because you didn't actually have a court hearing from 10/5 of 2012, yes, until the trial clerk's mail returned. Well, you didn't have one on 12/31, yep. You had trial clerk mail returned at trial clerk. February 11th of 2013, yes. And the mail was returned unclaimed on the 13th of February. Brief order for support. Now, if you declared a mailing on 9/25 and 9/25, yes, and the mail was returned unclaimed, yes. And then, where was the declaration of mailing for the February 11th of 2013 hearing? Well, there was two declarations of mailing, right? One was on September 25th of 2012, yes. I'm thinking it must have been for this motion hearing. Right. You could have mailed me the parenting plan, the temporary order of child support, so on and so forth, so on and so forth. Because we'll look at the actual calendar. Ooh, 10 days doesn't seem like 6 days between. Um, well, you didn't attempt any mailing, but what mail was returned unclaimed on February 13th? It would have taken at least 3 judicial days to get to and from whatever location that you mailed it to. Yes. Now, this local family law rules of court setting the hearing and submitting the motion materials to the other parties. These are known as motion materials. Yes. The temporary order, parenting plan, temporary order of child support. Yes. Yes, it is. Well, the motion materials I never received. Um, what'd you do? Now, if you're telling me that this was declaration of mailing, and the mail was returned unclaimed, and only one of them was returned unclaimed on January 14th of 2013, and the other mailing was returned on February 11th of 2013, I think there's a limitation to the amount of time that you can wait for a response from a declaration of mailing. You know, I did look at this whole mailing of different documents to those that are named as parties to any motion of any court hearing. Yeah. One of them has to be first class mail. Now, court rules might be different for this. I don't know in family law. I'm just learning about it right now. And the other should require signature receipt from the postal service. Yes. Now that would be registered mail. Yes. But it requires because I do understand about protection orders. Yes. See, when it says here, service by mail pursuant to court order. Yes. You might want to read in the judge's guide. Because you send one of them first class mail that does not require signature. Yes. And you send the other one registered mail or certified mail that does require a signature. Yes. And that has to be put in the file as proof of service prior to having the court hearing. Now, I have a difficult time believing that this mail returned unclaimed from this, that would have been October, November, December, pooch, October, yes, approximately 30 days, November and December. 90 days and you get mail returned unclaimed. Yeah. You know, I I would think in the worst case scenario, okay, in one of these, well, there was a lot of snow that year, or maybe it was the year before when I was staying at my grandmother's house. Yes, there could have been some sort of hurricane that I wasn't aware of during the time I was staying here. Yes. Postal Service was shut down. They were shut down for 90 days. Pow, 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 pow. There must be some other excuse about why it was that for 90 days, yes, because we'll look at it, okay? Go to date. Now, she mailed it on, oops, oh, look, I didn't know it could do that. Go to date on September 25th, yes. Mm-hmm. And, or there's a declaration of mailing. I'm thinking it might have been before or after that, or maybe you just declared you mailed it and you didn't. I don't know what the actual forms are necessary. Yes. But on the 25th of September, yes, that would be all of October, right? All of November, yes, and all of December. Pooh. And then there's a mail returned unclaimed approximately 104 days later. 104 days later. It really looks to me like the petitioner wasn't trying that hard to contact me as the father of five sons. Yes. Now, there must be some sort of legal rules in the family law manual for those that are elected to be judges, Superior Court judges. Judge Rohr, Brent Baisden. But I'm thinking 104 days before a mail returned unclaimed is excessive. Now, let's say you're violating some laws that protect my rights as the actual individual named as a party to the dissolution of marriage. And you decide to wait for 104 days, right? You find out about it. A week later, you say, "No, we're going to go ahead with the actual hearing." Yes, and we're going to do it on February 11th of 2013. Yes, petitioner's trial brief. Yes, yes. Order for support, factual findings, so on and so forth. There's no declaration of mailing here. No. There's no attempt of service. No. No, there's not. There's no 12 judicial days before court hearing. Yes. There's no motion paperwork. Yes, yes, yes. There's nothing. And then you get a mail returned unclaimed on February 13th of 2013. Yes. That had been sent, yes, approximately, well, if it's 100 days to here, at 140 days before that. 140 days before that, the mail was returned unclaimed. Now, when I talk about kidnapping and custodial interference and child abduction, every time you admitted, yes, after the declaration of mailing, in fact, every time you admitted each and every one of these documents, yes, and then each and every one of these documents, yes, this declaration and sealed confidential report, and then every one of these documents, yes, I'm going to sue you for every one of them. Every fucking one of them. Now, I don't see that the court obligated the petitioner to make sure that there was a legitimate, authentic, genuine attempt at notice of hearing. Yes, I don't see that anywhere in the Superior Court case summary. Poop. Now, when I told you I wanted you to enforce the laws and you refuse, who, um, that 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 kidnapping now is the court is actually guilty. Yes. Now, I decided to email some persons, the Young Lawyers Division of the Hawaii State Bar Association, the Georgia Bar Association, yes, and the South Pacific Bar Association, yes, and this whole concept of organic documents, yes, the possessions and territories of the United States. I looked at this Treaty of 1878. Yes. Yesterday I told you about the Organic Act of Guam. Now, the Judge Advocate of the Navy, the transfer administration to the Secretary of the Interior. Yes. The establishment of naval stations in other possessions and territories of the United States. Yeah. The Constitution of the United States, the American Samoa Bar Association. It looks like a lot of these other, well, territories and possessions of the United States, they've had some rules and some influence of the United States. And then there's the whole concept of immigrating to the United States. Let's say you lived in a territory of the United States or a possession of the United States, and there was some sort of agreement that you would give preferential treatment to those that immigrate to the United States because of these organic acts. Why don't you give me all the immigrants to the United States from every territory and possession of the United States and all the organic acts that Navy had negotiated during the time or after World War II? Yes, yes, yes. The secession of the Manus Islands? Yes. Tutulia? The executive order placing Samoa under the United States Navy? Yes. I'm going to go through all of the members of the South Pacific Bar Association. Oh. And I'm going to look at the immigration status of all of those that have a right to immigrate to the United States of America. Now you're going to get sued, okay? Washington State, yes. You're going to get sued, pooch, for violating certain conventions, yes. Organic acts, yes. Constitutions, bar association requirements, pooch, of any and all nations that have favorable status of immigrating to the United States of America.